Hello, thanks for joining us. I'm Curt Pringle, and this is another edition of our Talking Issues series, where we really talk about public policy issues in California. And one of the things that a lot of people talk about, but maybe others don't necessarily know the depth or the information behind it, and that is the ability to do business in California. Is it tough? Is it really tougher than other states? What do employers have to go through? And in that regard, one of the biggest challenges is really employment law in the state of California. It's different than other states. And, I wanted to talk with my attorney in the employment law area, Erick Becker, who's with the law firm of Cummins White here in Orange County, working all through California. But really, he is a specialist on employment law and how the California legislature and the governor and the administrative state have changed that over the years. So welcome, Erick.
Thank you, Curt.
Glad you're here.
Happy to be here.
Yeah, no, and I mean, it's really something. I mean, I grew up in the family drapery and dry cleaning business. We've always had employees, and I don't know if my dad was totally in charge of the business today, if he would be able to handle all of the array of employment law issues that we have. So, uh, this will be an interesting topic for some, maybe not for others, but I hope everybody hears just the battle, small business particularly, but all businesses face in the state. So what would you say are some of the biggest differences between having a business in California or business in another state as it applies to employment practices?
So I think there's one very large issue that small businesses in California face that they don't have to face in other states, and that is wage and hour compliance. Most other states follow the federal law, and the federal law is much more forgiving for employers.
Yeah, so wage hour rules, so that there's a lot of them. So it's not just, I mean, when I was in the legislature, I know there was a battle with whatever it is, the State Department that regulates labor standards, and it was the battle between a 40-hour work week and an 8-hour work day.
Correct.
Whereas a lot of people said we want a 40-hour work week, and not up at the state went to an 8-hour work day. So
Correct. So
that changes that whole dichotomy in an interesting way.
yeah, so that's a one very good example of the difference between California and other states. Here, we have what's called daily overtime. So if you work over 8 hours in a workday, you are entitled to overtime pay if you're a non-exempt hourly employee of 1.5 times your regular rate. In other states, it's based on 40. So
40 hours in a week.
40 hours in a week. If you go over 40, you're entitled to overtime. Another little piece of this that a lot of people don't know about is I mentioned it's based on the regular rate.
Right.
And so if you pay somebody some sort of incentive bonus, hey, I just need you to show up on time. If you show up on time the entire month, I'm going to give you $100. Great. Thanks, boss. Well, that bonus is what we call a non-discretionary bonus, and it has to be added to the regular rate in calculating overtime. Most people don't know that. You know who knows it? Plaintiff's attorneys.
Yeah. Right.
And I deal with a lot of cases, unfortunately, where employers are trying to do the right thing. They're trying to incentivize their employees, pay their employees more, and it ends up biting them because now
it's blended into that quote hourly rate, whatever that was.
Yeah, and they're incorrectly paying them less overtime than they're owed.
Yeah, it is one of those interesting things because I again remember back in the 90s when sitting in the legislature when this whole issue was being debated.
Yep.
And there were a lot of people who spoke who were hourly workers. I know this sounds interesting or strange, but the secretarial administrative staff at Rockwell, Anaheim. It was Rockwell at the time before it was bought by Boeing. But those workers wanted the 40-hour work week because they said, I want to work a little over today so I can take 2 hours off tomorrow because I want to catch my son's baseball game.
Yep.
And therefore, if I'm stuck to 8 hours and my employer doesn't pay overtime, I can't work 10 hours on one day and fewer hours the next. So And I also know some people said that was much more of a focus on pushing people into a collective bargaining agreement, a labor union-based relationship, because they can negotiate those things, whereas the individual employee in a business can't negotiate working 10 hours today and 6 hours tomorrow.
Yeah, most of the labor laws, employment laws dealing with wage and hour all have collective bargaining agreement carve-outs. So you've got a union contract, then you don't have to worry about this. You can negotiate something different with your union.
Yes.
And of course, the reason for that is that the unions want to drive more employers into signing a union contract.
Yeah.
So, mentioning that lack of flexibility, that is definitely a double-edged sword for employees, right? Because on the one hand, California, by their rules, allows them to maybe get more overtime pay than in other states. But as you said, now it's very, very inflexible, right?
Uh-huh.
If I allow you to work a little bit more, I got to pay you overtime, even if you're willing to make it up. There's some arcane rules about how you can go about having makeup time. Most people don't do it because it's a trap. It's too easy to get tied up and do it wrong, and that creates a lot of problems in the workplace. You're mentioning administrative staff. A lot of times I deal with situations where the employee is arguing, no, I should be exempt, right?
Yes.
Because of my job and because of what I'm paid, I should be exempt because I don't want to have to punch a clock. I want to be able to work when it's convenient for me. And I have to advise my clients, look, that's very dangerous to classify somebody as exempt, because the burden is on you to prove exempt status, and it's very gray.
Right. So let's make sure people see the difference. So there really are two buckets, right? I mean, an hourly structure that everybody's familiar with, and if you're not hourly, that next category is an exempt employee, which means you don't live by some of those same hourly rules. Um, uh, because you have some independence in how you work and, those types of things. So what are those definitional requirements to have an exempt employee?
Right. So in order to be exempt, this again is one big difference between California and other states. We have a much higher threshold in your salary for exempt status.
Yeah.
Right now it's $68,640. That has to be your minimum salary to be exempt in California. In other states, it's far less.
Yeah. So, but that salary is, we're starting this conversation talking about the difference between California labor law and other states. One of those is also the minimum wage law in California. The minimum wage is much higher than the federal minimum wage, and therefore much higher than many, many other states' minimum wage.
Right. And the minimum salary for exempt status is tied to the minimum wage.
Right.
It's 2 times the minimum wage.
And when did that go up? I know it used to be 1.5. The exempt salary had to be 1.5 times the minimum wage, but somewhere along the last couple of years, the law changed to 2 times the minimum wage.
Yeah, it's been a few years,
Yeah.
and it goes up every year
Mm.
because when the California minimum wage goes up, the exempt salary goes up.
So what is the minimum wage now?
$16.50.
And then what is therefore, with that as the minimum wage, in law, are there specific rates for overtime or weekend time and things like that?
No, there's the overtime laws are 1.5 over 8 or over 40.
I see.
2 times double time if you go over 12 in a work day. And then on the 7th consecutive day worked, you get overtime over 8, and then double time over that.
And those are all written in state law.
Yeah, that's all in the wage orders, correct?
Right. So you started this by talking about all the wage and hour issues that really distinguish a lot of California employment from other states. So I drug you off track. Sorry about that.
No.
But why don't you finish sharing what some of those other issues are? Because those are really some of the tricky places that employers get caught up in.
So I think the other big category is California has rules regarding offering rest periods and meal periods to employees.
Mm.
Now, other states have some rules that are similar. The difference with California is if you don't provide a rest break, 10 minutes paid for every 4 hours worked or major fraction thereof, or you don't provide a 30-minute meal period that starts by the end of the 5th hour of work, so there's lots of different hoops to jump through, then there's a penalty. And that penalty is 1 hour of pay for the employee. So that is probably the biggest source of litigation that we have to deal with in our practice for small businesses. It is, and I don't think this is overstating it, it is next to impossible to manage making sure that everybody is taking their meal period when they're supposed to take it, they're clocking out correctly, and they're taking the full 30 minutes. And it's impossible to prove that employees have taken their 10-minute rest period. And so we get a lot of cases where employees come in and say, oh, well, I didn't get my rest periods. Well, yes, you did. Oh, no, I didn't. It's a he said, she said dispute, right?
And back in the day, there used to be a threshold. A lot of these labor law, employment law issues triggered if you had over 100 employees. But most of the laws today in California trigger at what level of employee?
Right? One.
Yeah.
When we talk about wage and hour, if you have one employee, you have to follow the wage and hour laws. There is no threshold. So that is a major problem for small businesses, not just for the administrative part of it, of trying to make sure that you've got your record keeping correct, you've got a time system that is recording hours correctly, as well as these meal periods, you've got your policies in place. What tends to happen, Curt, is if somebody's let go, doesn't matter what reason, they go to a lawyer and the lawyer says, I don't care about your termination. Tell me about meal periods and rest periods. And off we go. So that's the biggest challenge, I think, in compliance for small businesses is this whole meal and rest period issue. So
yeah, and those are challenging. I mean, and we'll talk about it in a minute, but a lot of that enforcement comes through the private attorney general action issues known as PAGA, which allows for the individuals to hire attorneys, and those attorneys basically are, just as it says, private attorney general, so they can sue on behalf, quote, of the state and such.
That's right.
Yes.
And they can seek the penalties that the state would normally collect for wage and hour violations.
Yeah, so let's get into that in a minute. But in terms of wage and hour, so our a new element of a lot of this is sick leave or sick time that now is mandated by the state, correct?
Correct. So the state mandates that all employees who have worked at least 30 days within California get 5 sick days, paid sick days a year.
So if you start to work for an employer on January 1st, you get 5 sick days, or if you start on December 1st of the year, you get 5 sick days.
You have to be able to have 5 sick days in your bank within 200 days of starting with the employer. And the employer can have policies that say you can't use your sick leave until you complete 90 days. But you start earning it when you start employment. Now, there's different ways that people can earn sick leave. Most employers use what's called the lump sum method because it's a lot easier. And that's just, look, at the start of the year, here's your 5 sick days. Use them whenever you want.
Right. At your direction, that's how we operate here.
Yeah. Yeah.
And then if they don't fully utilize those, they also can roll a portion of them forward. Right?
If you use the lump sum method, you can basically zero them out at the end of the year.
Okay.
Unless you're in certain jurisdictions, like the city of Los Angeles, that have their own sick leave law.
Really?
That allows people more sick leave and allows them to roll it over. So, again, under the state law, you can do the lump sum. It zeroes out at the end of the year. If you use what's called the accrual method, which is you get 1 hour of sick pay for every 30 hours worked, then that has to, unused sick leave has to roll over up to a maximum of 80 hours. So it again, very arcane, right? Lots of different rules. And you also have to report the sick leave balance on the pay stub.
Right.
If you don't do that, that's a violation.
That is such an interesting point. I mean, we have a small business here, and you would think we could manage everybody's ins and outs on sick leave and vacation time, but all of those balances have to be reported on your a pay stub,
Yeah.
which to me, thinking back when my mom did payroll at Pringle's Draperies, I mean, she would have had a hard time keeping up with all of that with 30 employees.
Oh yeah. And, again, going back to some of the other differences of California, one of the things that California has is a law that says that you've got to have 9 categories of information on your pay stub. And if you're missing a category or it's incorrect, that triggers a penalty. So there's a lot of cases where, let's say it's Pringle's Drapery Inc.
Right.
But you just put on your pay stub Pringles.
Right.
Well, that's confusing for employees. They don't know who they're working for. Therefore, that is an inaccurate and illegal pay stub.
Mm.
So there's all sorts of traps for small businesses. And even if you use the large payroll providers like ADP and Paycom,
Right.
they're all, for the most part, based outside California. And I've had numerous cases where they're doing it wrong because they don't know California law.
Wow.
Yeah. So it's
So what are the other mandates in this area of hiring employees and paying them properly and making sure they have the proper benefits? What else do the laws in California require of an employer? How about vacation time? Does the state law require that?
No, the state does not. Don't get any ideas, legislature. State does not mandate that you pay vacation. What the state mandates is that if you pay vacation and you terminate and there's vacation on the books, it has to be paid out upon termination.
Right.
If you don't,
that day or the last day of separation.
if you, the employer, terminate, it has to be on the day of separation. If the employee quits, you have 72 hours. And by the way, that's 72 hours, no holiday, weekend, doesn't matter. The paycheck has to be given to the employer or made available within 72 hours. And it's got to include vacation. The state does not mandate holidays. You don't have to pay employees for holiday pay. Most employers do, but that's not a state mandate.
I see. Therefore, they don't define anything as a employee-based holiday. So even though the state may take a holiday, they're not requiring a employer to shut down that day or pay overtime for or holiday
Or
pay.
holiday pay, yeah, absolutely. So really, the only benefit that's mandated is the sick leave.
Well, what about maternity paternity benefit?
So
that has dramatically changed in the last couple of years.
Right. So there's two facets of that. One facet is if you take maternity or paternity leave, you can apply for paid family benefits, but that is paid through the state. That is part of the SDI taxes that are deducted from employee paychecks and are paid by employers as well. So you can go to the state and you get up to 80% with some maximums of your salary while you take up to 12 weeks of leave for family care, whether that's to care for a newborn or potentially to care for another family member who's got a serious illness. Putting that aside, the state says if you have 5 or more employees, you have, and the employee has worked for at least a year for you, you have to grant them what's called CFRA, which is California Family Rights Leave. So employees get up to 12 weeks to take time off to care for a family member who has an illness or to care for a newborn, what's called baby bonding leave. But that is not required to be paid. The only thing that is required is you have to keep the employee's health benefits in place. The employee still has to pay their portion of the health benefits. So it's a leave mandate. It's very similar to the FMLA, but of course the FMLA, which is the Federal Family Medical Leave Act, only applies if you have 50 or more employees. California about 6 years ago said, we're going to bump that down to 5.
Yeah. And that is just such a challenge to think that you have 5 employees. Each one of them is critical to the operation of your business. Yet someone who leaves on family leave for 12 weeks, that spot is left open.
They have reinstatement rights. And the other thing that can be very difficult for employers to manage is they can take it intermittently.
I see.
They don't have to take it all at one time. So I might say, hey, I need to be off next week. I'm going to take 1 week of my CFRA, and then 2 months from now, I'm going to take another 2 weeks.
Yeah. So so you said that is basically 80% up to, I'm sure, cap, 80% of that employee's salary for that time. And if they take that over many times throughout the year, a portion thereof, who pays for that? I mean, at the end of the day, I think a lot of people look at things in California and say, oh, that's coming from the state government, but it's not. It's a separate insurance fund primarily, isn't it?
Yeah, it's coming out of the SDI tax.
Right.
The state is always
so SDI stands for state
disability insurance. Yeah.
So that is a insurance pool of all employers that they contribute based upon the risks that employer has in terms of their employees, or
it's a straight tax rate.
So it's a tax. What is the tax rate?
Oh, gosh. SDI is it's a portion of your tax that, like Social Security.
Right. So it's
the employer pays. The employer pays it.
A share of it.
The employee pays their portion of SDI, and the employer pays their portion of SDI. And it's a percentage, basically.
Right.
It's just a percentage.
Yeah. I didn't think there'd be anything I could ever ask you that I would stump you. So I love that. But I thought it was, I don't know, this might be historic, around the 3% range, but whatever it is a percentage that an employer pays for, even if they're a small employer and nobody in their operation leaves, it's that insurance policy. And thus, employees also pay a portion thereof. I mean, if that wasn't there, for example, there would be more money available for the employer to retain or the employee to receive.
Correct.
I mean, so Social Security, that's federal, that's the same type of system.
Same type of system.
Where the employer pays usually half the contribution or something like that.
Yeah. Well, it's like, Social Security is like 7.5% paid by the employer, 7.5% paid by the employee.
And then Medicare, Medi-Cal, whatever that is, same type of thing on a federal basis.
A percentage basis.
So that is unique to California in terms of the SDI as to what the California risk is for that payment, right? Because that's not a national fund. That is a state fund.
Correct.
So in that fund is different than the unemployment insurance.
Right. It's all managed by the EDD. I use the word managed very loosely.
Yeah.
But it is all managed by the EDD. So there's a separate tax for unemployment.
Right.
And then there's a separate tax for SDI.
So employers see this as they calculate everybody's paycheck. Sometimes the employees don't see all of the elements that are coming out of that paycheck, which is a share of that contribution. Or, for example, during COVID, you had 20, 30, 40 billion dollars worth of fraud from California unemployment insurance.
Oh, yeah.
And therefore, that just didn't come out of general taxes. That increased the tax rate that everybody, employee and employer, pay for that employment in California.
Yeah. And because of all that, the state is still trying to get money from the federal government to cover the shortfall.
Yes. I hear people on the state side are really negotiating nicely, trying to get that. Let's see how that works out. So I mean, in terms of all of those benefits, what happens when an employer gives benefits over and above the state required benefits, like vacation time or other types of benefits? I mean, is there a tax obligation to any of that?
Well, if you're paying vacation,
Right.
you're paying their wages, right?
Okay.
Holiday pay is wages,
Right.
so you're going to be taxed on those wages, just like the employee is going to be taxed on those wages. Yeah,
Right. But
yeah.
anything else in terms of getting tickets for something or meals, are those uh, taxable by the employee?
Well, so certain penalties are not taxable.
Penalties.
Penalties, right?
I see.
So, if like we talked about PAGA,
Yeah.
right?
Right.
If there's a PAGA settlement
I see.
and people are getting paid out of a PAGA settlement, those are considered penalties, and they're on a 1099. They're not W-2 wages.
I see. So let's talk about private attorney general actions in California. That um, I did that originate in California law, uh, where you have a private attorney general, therefore private attorneys enforcing state law, and therefore they are hired to enforce state law. And as you point out, the one of the largest areas in terms of employment law are these wages hour issues. Uh, and what percentage would you say are based upon an employee saying, I was not given the right amount of time for lunch and breaks?
Close to 100.
Is that right?
Yeah. Yeah. I mean, when we see PAGA cases come in, so in a PAGA case, you have an individual employee who goes to an attorney, and the attorney says, I am going to bring a PAGA action on behalf of you and all the other non-exempt employees. And I am stepping into the role of the attorney general, trying to enforce California's labor laws, which all have within the statutes certain penalties for violations. So, we see almost always in every PAGA lawsuit a claim for meal periods, a claim for rest periods, a claim for either minimum wages, because I worked hours off the clock and I wasn't paid for that, and that's a minimum wage violation, or for overtime, or both. Inaccurate or incomplete wage statements, waiting time penalties. So if I'm terminated and I wasn't paid all of the wages that I was owed upon termination, there's a penalty for that. And then oftentimes we'll see what's called a Labor Code 2802 claim, which is reimbursement for necessary expenditures that the employee has made on behalf of the employer. And what we've seen over the last couple of years is cell phone claims, where people say, hey, the employer required me to use my personal cell phone as part of my job because the supervisor would text me after hours, and I deserve reimbursement for at least a portion of my cell phone costs. So those are almost always in every PAGA case.
So a manager who is staffing for a restaurant, somebody calls in and says they can't make it, and then you get a text as a waiter that's not on that day saying, "Hey, can you work?" Is that even though it's not required to work or not, but is that a work related contact? Yeah. So all of those things. I mean, it's hard to comprehend that. Otherwise it would just be a phone call back in the old days.
Right, right. Well, I mean, we're also dependent on our cell phones now.
Right.
It is the natural thing to do, right? If I'm a supervisor,
Right.
I've got everybody's cell phone number. I'm not going to pick up the phone. I'm going to thumb out a text.
Right.
And obviously with most hourly workers, they're not getting a company cell phone. So you're being required to use for a portion of the time, your personal cell phone for a business use.
Yes.
And that the problem with a lot of these laws, frankly, is there's not a lot of case law to interpret where the line is between what is nominal or de minimis and what should be reimbursed. And frankly, nobody really wants to take them all the way up through the court system because it's costly, number one.
Sure.
And both sides probably have some incentive to have a little bit of gray area there because I can still make those arguments.
Right. So, but in that regard, as the fire truck rushes by here, yeah. But in that regard, so one individual files a claim as an attorney, and then basically they proceed in this lawsuit. So let's get to the end. I mean, at the end, you've shared with me before, one of the challenges is building up legal claims, both as an employer, defending yourself, and then if you lose, your mandatory requirement to pay the attorney's fees on the other side.
Yeah. So California, again, pretty unique compared to other states, has what we call one-way fee shifting. So if you're the employer and you take it all the way through and you win, you can't go after the other side for your attorney's fees. But if the other side wins, they can go after you for their attorney's fees. And so even if it's a minor violation, the other side can make an attorney's fees application. And most of the time, the court is going to grant a significant level of fees. In a PAGA case that goes all the way to trial, you could be looking at the other side claiming that they spend $500,000 to $600,000, right? And so that is, and that's true also in discrimination and harassment cases. Same thing. If you lose, you got to pay the other side's attorney's fees. But if you win, you don't get your attorney's fees back.
Pay your own.
You pay your own. So it's
nothing else in relief.
So what I always say to employers is, so great, we take this case all the way through trial. We won. Yay. How much money did we spend to prove we were right?
Yeah, but let's talk about winning, right? So that's why you have a lot of settlements. That's why insurance costs are high, because you have insurance carriers that protect that business to a certain extent, right?
Yep.
So let's say someone files a challenge on their wage and hour issues. Let's not even challenge whether that was a legitimate claim or not. It was just done. So you're in this system under this PAGA concept, private attorney general action, and the employer and his or her insurance company says, okay, let's just settle for $100,000. Let's talk about where that $100,000 goes, because I think this too is unique to California because of the private attorney general action. The first cut on that $100,000 settlement to the employee is to whom?
So let me just back up real quick before I talk about that.
Yeah.
So another thing that's very difficult for California employers is, like we've seen with the fire things, the insurance companies will not insure you for PAGA or class action wage and hour claims.
Okay.
They are excluded from any type of employer practice liability insurance. About the best you can get is what's called a defense costs rider, which maybe pays $100,000 to $150,000 of your attorney's fees. So it's coming out of the employer's pocket.
Right. So now you've basically redefined why the battle over PAGA was not so great if the insurance companies were cut out of having to pay. I mean, traditionally, the battle in Sacramento is between the trial lawyers and the insurance companies on a lot of these things.
Yep.
And therefore, if the insurance companies aren't fighting on behalf of themselves and their clients, the employers, then that's why maybe some of these laws were implemented. But go ahead. So there's a $100,000 settlement. Okay, this is the best you can do. Let's just resolve this. This one employee has been a trouble employee or whatever, but let's just resolve it. $100,000 settlement. The employer agrees to that.
So out of that $100,000 right off the top, the plaintiff's attorney is going to get 33%. So $33,000. Okay. Then there has to be an administrator to administrate the PAGA settlement. They're going to charge anywhere between $7,500 to $10,000. That comes right off the top.
Okay, so we've taken $43,000, let's say, out of that bucket.
Yeah, and then the attorney gets their costs, hard costs that they've sunk into the case. Usually about $7,000. So now we're up to $50,000, right? Now the plaintiff, the employee who brought the case forward, gets what's called a PAGA representative fee. They usually get between $5,000 and $10,000. Okay, so now we're up to $60,000. We got 40,000 left. Out of that 40,000, 75% goes to the state of California.
Right. So the state has created this to say, yes, you can represent us, but we get 75% of the settlement after the lawyers are paid and after this nominal amount goes to the plaintiff, the individual.
Yeah. So it's basically a bounty hunter law, right? It's what it's been called.
So then our formula, we're down to $10,000 left after 75 off of 40. I do my quick math.
Yeah.
And therefore, that's distributed among all the employees that are a part of that same class.
Based on the number of pay periods they worked.
I see.
So, people get a couple $100 if they work the entire PAGA period, and maybe, 1,000, something like that. Yep.
So one of these clients of mine who has a number of restaurants in Southern California and other places in different states just told me not too long ago, we will not be opening any more restaurants in California. And I thought much of that was based upon the fast food requirement on minimum wage, but in fact, it also is like this private attorney general action PAGA issue that, you face at every one of these businesses.
Restaurants are particularly susceptible.
Right.
Because, again, we talk about employee flexibility, right?
Yep.
So if I'm a server, what am I relying on more than anything else? Tips.
Right.
Right? I don't want to take a break.
Yeah.
I want to keep working.
Exactly.
Or
tips. I've been working here for so many hours, and my manager tells me I have to take a break, and I've got 6 tables.
Correct. So maybe I punch out a little bit late.
Yeah.
So yeah, restaurants get hit with these quite often.
So we all hear about the restaurant minimum wage discussion. So quickly explain that. I mean, the state legislature created a new minimum wage above the $16.50 an hour that goes up so much a year by state law, but they also created that fast food definition of a minimum wage.
Right, and you have to have a certain number of locations in order to trigger the.
But not that many.
But not that many.
Right.
And then you have to pay your employees a minimum of $20 an hour. That hasn't gone up yet. There's a fast food commission that is made up of employers, labor representatives, and employees, and of course politicians, who meet and are going to decide when the fast food minimum wage should go up, based upon CPI, all sorts of other different factors. They were talking about boosting it up to, I think, 2075, but they haven't taken a vote on it yet.
I see.
So basically, that is dictated by the state.
And the exempt law for managers. So if a manager of a fast food restaurant manages that team, he or she is not getting that same exemption as terms of a salary, which is 2 times that fast food minimum wage. They're still getting 2 times the state minimum wage.
Correct.
See, I mean, I would be concerned if I owned restaurants like that would be modified a bit somewhere down the line, because those two start getting closer together when you're pushing up the individual workers minimum wage, getting a little closer to the manager's minimum wage.
Sure.
Or minimum exempt salary. So
sure.
Yeah. So sorry, I'm going down a rabbit hole, but really one of the major things that really happened in employment issues, I think, is COVID, the remote work emphasis. So what do employers need to be aware of or concerned about as it applies to some of their workforce working remotely?
Yeah, it's a great question. So if they're working at home, all the same laws and rules apply, right? So
you need to make sure
you still have to track their hours. They still need to punch out for their meal periods. They still have to take. I've had multiple cases where people were fully remote, claiming that they never got a rest period. You're at home. Nobody was standing over you saying, now it's time to take a rest period.
Yes.
Oh, I was too busy, right? So that is a challenge. You still have all of the safety requirements. You still have to provide a safe workplace, including ergonomics. And then you have the issues of reimbursement for necessary equipment that is used to work at home. So, if the employee is using their own personal computer, uh, you've got to reimburse them for their internet. You've got to reimburse them for
Their office space.
for their not for their office space necessarily.
All right.
But there's no cases out there that talk about electricity or any other utilities. I mean, the general rule that we've all followed is, well, you're not you're going to have the electricity on whether you're working at home or not, so it shouldn't be reimbursable. But Lord knows, maybe some court will decide otherwise. But I think the biggest challenge for remote work is, how do you as an employer know that people are actually working?
Right.
We've had a number
There's
of
a commercial out there where they hear parrots in the background, right? We don't know where he is at.
well, I've had a number of cases where people are working 2 or 3 jobs, right?
Yeah.
And like, why aren't they getting their work done? Well, because they're working for somebody else at the same time. So I've had some employers, well, can we put a video camera on? No, I don't think that's probably advisable, but there are some systems with keystroke monitors where employers can make sure that people are actually sitting in front of their computer, on the Slack channel or responding to emails, doing work. But again, that's an investment, right?
Right. Well, and I know government employees. The governor of this state, for example, is slowly encouraging folks to get back to work, state employees. And a few years ago, he went to a requirement for 3 days a week having to work on site. I don't know how well that went, and I know there's still a battle going on about going to work 4 days a week.
Yeah.
And I think that's one of those questions.
Yeah, there was an article in the Register this morning about there was a study that it's more efficient to have people work at home than this state government employees.
Well, I don't like to reference exactly things that were in the paper on any specific morning, but let's say that article in the Register, when it appeared, the biggest savings, therefore the efficiency that they pointed out, was the lack of office space need.
Yeah.
But therefore, if it's a state office building, you're not getting any savings, because if there's one person working on the floor in the ED department or Caltrans or something, that floor has the lights turned on, and probably the air conditioner for the one person, not the 150 that otherwise would be on that floor. So I don't know. I might question a little bit of the savings that was marked up as to what they reference would be the benefit of that. But yeah, I mean, it is, we don't have private employers, we don't have some of the benefit of having large state workforces, but the union control of many of those workers, I know, will be a battle for large employers and large government employers as well.
Yes. I have seen that for most employers who have brought people back, there hasn't been a lot, as much pushback as I would have expected. What we have seen is people going to a doctor and saying, because of my disability, I need an accommodation to work at home. And that triggers a lot of duties on the part of the employer to engage in an interactive process to determine whether or not that is a reasonable accommodation. So we have seen some of that, people trying to get around the return to work requirement by claiming, I have a disability and I have to work at home. So yeah, there's been a lot of challenges with that, but I think that is beginning to sort itself out.
Right. Well, the whole issue of employment law, I guess, in this age of AI and talking about the future of employment, I think if people followed your path, Eric, and became employment lawyers, there would probably be a lot of work always for someone as, the economy continues to move in that direction. So I really do enjoy hearing all these things, even though they are face the challenges of a California employer, but I think it's really important for people to know that. So thank you very much for coming in today and sharing with us.
My pleasure.